welcome everybody to our session today. We got a couple topics that we're gonna cover today, and so and I'm going to try and, as always, do within our time frame. So we're going to be talking about why deals fall apart, and then issues come up when you're buying and selling on the same day. And some of the issues you'll see are related, but I want to get right into it to make sure that we get everything covered today. So I'm going to skip over. You're familiar, I think, with our areas of practice. And my apologies. We've been trying to do this every other week, and last week I wasn't available. So I think we've had a 3-week gap for doing these webinars. So I'm sorry for that. But the good news is we're going to do another one next Thursday on non-resident issues. So it should be a good one to tune into if I forget to mention again next week. So anyways, please follow us at all the social media. For those of you that aren't aware, I've been doing a podcast now, which is available wherever you can find podcasts. It's also available on YouTube. We now have a YouTube channel, and you can, I think we did the 30-second recording on Wednesday, so I don't know if that's been posted yet, but you can find it. There's different topics each week that we discuss, and you might find some of that very informative. So please subscribe to our YouTube channel to check it out. It's called David and David on Real Estate. I do it with another broker whose first name happens to be David as well. He's an owner broker of a different brokerage, but we're talking in general. We're not just plugging up my firm and his brokerage. We're trying to provide information for the general real estate community out there. So anyways, I encourage everybody to try and tune into that if you get a chance. David and David on Real Estate. So there's my commercial for today. So let's get into part one: why real estate deals fall apart and how to fix them. And of course, from your point of view, as I'm going through this, we're trying to do this, how I try to fix them as a lawyer, but I'm trying to communicate to you some of the issues where you as agents can really be important, involved in the process to make sure they don't fall apart. And if they do fall apart, what we've got to do to fix them. So some of the typical issues that we deal with when we run into different problems with transactions closing, a lot of it deals with mortgage financing. So we're going to talk about that first. I want to get into a little bit of the concept of breach of contract, what that means, and tender, which is a term that you've probably heard of, and some of you probably heard of it but don't really know what that means. And we'll get into some other issues that cause problems on closings. So let's get into the mortgage and the financing, because that seems to be the biggest issue that causes transactions to go off the rails a little bit these days. So, and it's usually when a purchaser is just unable to qualify for a mortgage, or to qualify for the mortgage that they thought they actually had been approved for. So that's a problem. And you've got to remember, we're dealing with this in today's market climate. And we've been going through a significant period of time already where the supply has been really, really low. So as a result, every time a decent property comes on the market, we get into these multi-offer bidding wars. And it's pushing values up because people are prepared to pay more than what the true market value would be in a more normal market, because there's nothing else for them to turn to. So you get these multi-offers, and I really feel for all of you agents out there, because I know when you're on the buyer's side, you're working really hard to get a property for your client, and you make offers, and you show up and there's 10 other offers or 15 other offers. And you're going to lose a fair bit of these no matter what, because there's only going to be one winner on each of these. And then you got to go to the next property and the next property. So it's a very difficult market, as I don't have to tell you right now, for the agents. Now, we have seen signs, just, my little market update, and I think many of you would probably agree, we have seen some signs that there's more supply coming onto the market. We're now late February. Every single year, as long as I've been doing this, the market is quieter in the winter months, December, January, February, and then gradually starts to pick up as we get into the spring market. So this year should follow that. Hopefully this will not be an exception. And we're already seeing signs that that's going to happen. So that would be good news for all of us, because we need more supply out there, which will help alleviate some of the issues that we encounter when it comes to closing. So what happens is, we get these artificial prices for a lot of these properties. And people think they've qualified for mortgages for a certain amount. Maybe someone's been pre-approved They're looking to buy a property for $1 million and they got pre-approval for a mortgage for up to $700,000, let's say, just to throw a number out there. And all of a sudden they go and they find a property that's in a normal market might be worth $1 million, but now it's because there's multi offers. Maybe it sells for $1.1 million and they want to get it. So they had pre-approval, but so they go to the bank and say, hey, we bought this property for $1.1 million and you were going to give me 70% of the purchase price. So give me 70% of $1.1 million. And the bank says, or the lender says, no, we're doing our own appraisal and we're appraising it. And this should have sold for $1 million. It just got pushed up because of market conditions. It's really only worth $1 million. So if the buyer defaults and we have to resell the property in a normal market, we may only get $1 million. Therefore, we're still only prepared to give you 70% of the million. We're not going to give you 70% of $1.1 million. So now the buyer has to come up with the difference. There's a shortfall there. So if they have deep pockets, they've got friends and relatives to borrow from, they got other properties to finance, they've got to scramble and find a way to come up with the money, because if they don't come up with the money, they're going to be in breach of their contract. So we're seeing a lot of this. Okay, so what are some of the strategies and involvement that you could do as an agent to help avoid some of these mortgage issues? Well, the first thing, and this is a really important thing for you as an agent, it's really critical to your success as an agent to make sure you have a good team of people to work with. And that'll start with a mortgage broker. Make sure that you're introducing your clients to a mortgage broker that's going to give proper direction to your client and make sure they get proper approvals. Okay. And teamwork and team building is really important. And I talk about it in other webinars too. Me as a lawyer are an important part of your team. You want to have the right lawyer as part of your team. You want to have the right mortgage broker. You want to have the right appraiser, home inspection person. You've got to have the right people that are qualified, because otherwise things get off the rails and they're hard to fix. So you want your buyer to get pre-approval, especially in this market. You want to know what they can afford. So you want to have some sort of pre-approval, but you've got to be really careful what pre-approval means, okay? Because I see it all the time. Someone says, oh, I got pre-approved for my mortgage. Here's the letter from my lender that I'm pre-approved for a mortgage up to $700,000 on a property in the $1 million range. But the letter says that, but then it says, as long as you comply with the following conditions on Schedule A. And there's a dozen conditions on Schedule A, and some of them they may not be able to qualify for. So the pre-approval letter is not worth the paper it's written on. So you have to be very careful about what exactly you're getting pre-approved for. What are the conditions? How much underwriting was done? And it's something that your mortgage broker that's involved should be really paying attention to, but you as an agent have to be involved in the process to make sure they've got the right person giving them advice, that you're helping with that process. You're helping them get the information that the mortgage broker needs and that the lender needs, all their tax returns, their notices of assessment, their employment letters, things like that. Their other debt situations, credit reports, whatever it is that's needed. Because if it's a pre-approval, you're pre-approved subject to you complying with a dozen conditions, and they don't ultimately comply with that, they're not ultimately getting their money. So why have them sign a contract committing them to buy a piece of property when they may not be able to get the mortgage funding at the end of the day? Another important tip for you as an agent is you have to be involved with your clients. You have to really sit down with them and understand what they're looking for and understand their financial situation, and make sure you really get a grip on what is affordable and not affordable. Okay, especially when you're in a market like this, because there's going to be pressure on your client when they can afford that $1 million property, and they've been pre-approved for that $1 million property. But now when they go to try and put an offer in, and there's multi-offers, and that starts getting pushed up to $1.05 million, $1.075 million, $1.1 million, where is it going to end, and how far can your client really stretch to go? And is that really a good idea for them to do that and stretch and maybe make it becomes unaffordable? Maybe it's a better strategy in a current market to say, in today's market, you can't afford to buy a property that's really worth $1 million, because you might have to pay $1.1 million for it. You should look at properties that are $900,000 that you might have to pay $1 million for, because that's still affordable to you. Okay, if you get pushed up in a bidding war. So really be careful. You have to really understand your client. And all of this just makes your life as an agent more difficult than it should be. But that's how agents become successful, by digging down, really understanding their clients, understanding their needs, understanding how the system works, and going the extra mile so you don't put them in a situation where they're going to be compromised down the road. You also got to be aware that a bank appraisal is going to be generally different than the fair market value, which is the value that your client's actually signing under a contract. In a normal settled market, once upon a time when we had one of those, the best indicator of fair market value of a property is what a willing buyer and a willing seller just signed an agreement for. So if they just signed an agreement for $1.1 million, then that's really the fair market value right now of that property. But the banks don't look at it that way because they've been burned too often with these type of situations, because the bank's always looking at, yeah, that might be fair market value today, but if we are in some sort of a bubble and this bubble does burst and the values come down a little bit, and then this buyer goes into default, I'm not going to be able to sell this property for $1.1 million to get all my money out. It's probably going to get back to $1 million. And so the appraisals are conservative. They're at their lower values. Okay. Now, I've experienced on quite a few occasions where we've had a bank appraise something way below what the purchase price is. And then we've had the agents go to bat for the buyer and get in touch with the appraiser and say, hey, you may have missed something. Here's some other comparables. Here's what's going on in the marketplace. Here's what's going on over here. Did you know that? Did you actually go into the property? Was it a drive-by appraiser? Did they actually go in? Do they know that there's actually a finished basement? Do they know there was all this landscaping in the backyard or a pool was put in? Did they really do their appraisal properly, or was it just a drive-by appraisal? So as an agent, sometimes you can get involved in that too and make sure that the bank is doing a proper full appraisal. And I've seen appraisals adjusted after the agents got involved and gave additional information to the lender's appraiser and got it pushed up to a better value. So never give up is sort of the bottom line on that. Okay. Now, because that's always an issue, is whether they can there's a gap between the appraised value and the purchase price. That shortfall is a critical thing to be dealing with. So next thing I wanted to talk about is breach of contract. What happens if a purchaser gets cold feet or has buyer's remorse? They've signed an agreement and now they say, I think I overpaid, and I don't know why, what we were doing. We paid $1.1 million. We got caught up in the excitement. We can't afford to pay $1.1 million. This is going to kill us. It's going to change our lifestyle. I'm not sure if we can come up with the money. Maybe we can find something better if we want to pay $1.1 million. They get cold feet. What if a seller reneges on the deal? Oh, yeah, we took that, but I think we could have done better. After we signed that, a couple more offers were going to be presented. I think we could have done better. Can we get out of this deal and find another way to do it? So the real answer in this is no, you can't. Once something is signed, once it's under contract, we have to live with the contract. There's no such thing as buyer's remorse. There's the only time there is something like a cold feet buyer's remorse situation is in new construction, for a condo purchase. Okay, not a single detached home or a townhome. Only if it's a condo, because under the Condominium Act, after you sign an agreement of purchase and sale, there's a 10-day cooling off period. And that is a built-in legislative opportunity for a buyer to get cold feet and get out of the transaction for any reason they want. They don't need to give a reason. They have the legal right to get out of it after signing a contract. They've got that 10-day window. But other than that, and that's only new condos, not resale condos. Other than that, there's no such legal concept. You signed an agreement of purchase and sale, you have to live with the agreement of purchase and sale. You have to close your transaction in accordance with the agreement of purchase and sale. That's a contract. So we have to ensure that we're signing good contracts that protect the clients properly. So make sure you're doing your homework in terms of understanding the property they're trying to buy If you're on the buyer side, make sure you're drafting things properly. If you're on the seller side, make sure you're dotting all the I's, crossing all the T's. Make sure you've got proper legal descriptions. Make sure that everything is signed properly and everything has been initialed properly. You don't want there to be any of those issues coming up. There's certain documents that have to be delivered, after the agreement is signed, such as surveys. Maybe there's certain reports or inspection reports or things like that, or leases. Make sure if it says it's supposed to be delivered within 2 days of acceptance of the agreement, make sure that it's delivered within that time. Because if it's not, the party that was supposed to be delivering it, which would be the seller in those cases, will be in breach of the contract, and there's serious ramifications. So whenever there's a condition that has to be met and it's got a time element to it, you have to make sure that is met, that things get met on time. Because the absence of that is a breach of a contract that gives the right of the other party to sometimes get out of the contract, or they might be entitled to certain damages that might flow from it. And I'm going to talk a little more about time later on, because there's an important concept that's built right into every standard agreement purchase and sale. It says time is of the essence. So you'll remember that. We're going to get back to that concept. Time is of the essence a little bit later. But the important thing for now is that whenever there's a time element in an agreement, make sure that it's met, whether you're on the buyer's side or the seller's side. It's not a suggested time. It's something that has to be complied with. So when deals do go bad and the parties are perhaps not closing, one party or the other can't close, this concept of tender comes up. And I get asked about that all the time, like, what is tender? So tender means if you're the party, the innocent party, let's say I'm the seller and we're all ready to close. Our documents are signed. We've complied with everything in the agreement. But now the buyer, we understand the buyer may not be able to close because the buyer, let's just say they can't get their financing or can't get it in time or something like that. And we're told there's a problem. We're supposed to close today. It's February 24th. We're supposed to close today. We have to get this closed by 5 o'clock today. And now we're told it may not close. So my obligation as on the seller's side is to tender on the buyer's side to show them that we have done everything. Here's all our documents. Here we're tendering all our documents. We've answered all your title issues. We've cleaned up everything that has to be cleaned up. We've provided you with all the numbers. We've done everything on our part to fulfill our end of the agreement of purchase and sale, our end of the contract. So we're tendering everything to the other side, showing that we are ready, willing, and able to close the transaction today. So if it does not close today, it's clearly the buyer's fault. Because if we don't do that, and the buyer says, well, I don't think I could close today, and I might need an extension, I may not be able to close at all, and the seller takes his foot off the gas and says, okay, well, I'm not going to bother sending my documents or showing you that we were ready. If this does go to court, at some point, judge is going to say, hey, look, the buyer wasn't ready to close, but it looks like the seller wasn't ready to close either. So it's not all the buyer's fault. So that's why there's this concept of tender built in. So it really protects the non-defaulting party to show that they were in a position to close, and it's not their fault that the transaction doesn't close. So that's all that tender really means. And it's not something that you as an agent would generally have to get involved with. It's really important that the lawyers get involved. Where you might be involved to some extent if there were certain things that had to be delivered, like we needed this. Let's say we were giving them an original survey, we gave them a copy of the survey, but we agreed to give them the original survey on closing. That you make sure that the original survey is available, because that would have to be delivered to the other side. We have to show the other side that we have that original document to send to you. Okay, so sometimes you get involved because there might be a collection of certain documents or information to make sure that we're all in a position to close. Okay, so the bottom line with tender is those words that I'm going to repeat. It's the party that's not at fault showing they were ready, willing, and able to close, so that the default is completely attributable to the other side. Okay, we say I'm the innocent party, I'm the victim here, they didn't close, I was ready to close, I suffered damages, so judge, please make me whole, provide me with the damages. Because that's the first thing that a judge is going to look at, saying, did the non-defaulting party do anything wrong, or were they really ready to close as well? Okay, so that's something generally happens on the closing. So just so you understand that. Now, some other issues that come up that throw some deals off the rail. We run into some timing issues because the purchaser might be buying and selling, and that's sort of our next topic. They're buying and selling. Oftentimes they are, and they got to close their purchase, the money from, I mean, they can't close their purchase until they sell. They need the funds from their sale in order to complete the purchase. So if there's issues on their sales side and they can't get that closed, obviously that's going to affect their ability to close on the purchase as well. And we're going to talk about that a little more in part 2. Other issues that we deal with all the time that throw deals off the rails are title issues, because there might be problems. There might be some easements that have to be identified or cleaned up. There might be some litigation. There could be liens on the property. There might be title defects, things like that. Now, these are generally issues that you as an agent are not going to be dealing with. It's the lawyers that'll be dealing with. But where it'll come back to be important is, how was the legal description described in the agreement of purchase sale in the first place? Because if there was an easement for a mutual driveway between two parties registered on title, but there was no reference to that in the legal description that you used in the agreement of purchase and sale, that becomes an issue. So to avoid these type of issues, you've got to be very careful about how properties are described when you're drafting up these agreements of purchase and sale. And if you're not sure what these legal descriptions mean and the terminology that are used for easements and rights of ways and things like that, then make sure you bring the lawyer involved at that point in time. Say, I'm working on this deal, not sure the legal description. This is what I know. I'm not sure what this means. Do I have it all? Am I missing something? Maybe I'm not understanding it. Get it clarified, okay? And always err on the side of putting the full legal description. I don't care if the legal description is 3 pages long. Attach it as a schedule. Don't try and just put a short form legal description into your agreement of purchase and sale. It's only going to lead to problems down the road. Other issues that we should discuss a little bit: home inspection. Okay, and again, in this market, it's really difficult to get an offer that's conditional for a few days on a home inspection. Like, ideally, you would want that 100% of the time. You know, in our normal market, you sign an agreement. Now we got 2-3 days as the buyer to do a home inspection, and then we pay a home inspector. They come in, they take a look, and if everything's good, fine. If there's things that have to be fixed, there's a renegotiation to decide, is the buyer going to accept it the way it is? Maybe there's an abatement of the purchase price. Maybe the seller agrees to fix certain things before closing, but there'll be that renegotiation before the condition is waived. Unfortunately, right now, under these conditions, it's really hard to get a deal done that has an inspection clause. So what I would encourage you to do as an agent, as a good agent, if you're in that situation, is see if you can get an inspection done before the offers are being submitted. Okay, if they'll allow you access to do it, a pre-inspection before you submit the offers, at least you know what you're getting into. If that's not available, find out if the seller has already done an inspection report, and then take a look at that. Maybe they make that available to you. But be careful when you're with that, because the inspector will have done that report for the benefit of the seller. So if the inspector screwed up on the report or missed something, the buyer's not going to have recourse to go back against the inspector, because the buyer never hired the inspector to do it. He did it for the seller. So if you're using an inspection report that's being produced by a seller, you would also want to find out from the inspector whether the buyer can rely on that and get confirmation of that in writing as well, so that the buyer can rely on the truth and accuracy of that inspection report. So, but that's an important strategy. Unfortunately, these days, we're seeing some deals come in when there's been no pre-inspection. There's, they're just, they're multi-offer bidding wars, and they just say, we're fine, no condition. There's been no inspection, no opportunity to inspect. We're going to buy it, take our chances. You got to make it clear to your client that they understand what that means, because they are at risk. They are taking their chances, because when issues come up, they don't have recourse to go back against a seller most of the time, unless the seller did something to specifically try and hide things from anybody that would have seen things if they would have had an inspection done. But otherwise, they're on their own. They're buying it the way it is, and they're at risk. So you have to make sure your buyer really understands that. Okay. Now, Uh, Sometimes, we got people that are selling, they've got they got a couple months to find another place. They think they got plenty of time, and all of a sudden they're in a market like today where there isn't a lot in the market. They can't find anything. So all of a sudden they got to sell. They don't have anywhere to go because they haven't been able to buy yet. So there's timing issues you got to deal with. So there always has to be a plan and a backup plan. You have to have those discussions with your client. Yeah, you just signed. You're gonna close in 2 months. You're gonna be out. Hopefully, we find you something, match up the closing date or something close. But what if we don't? What's the plan going to be? Where are you going to live? Where are you going to store your goods? What's going to happen if we can't find something and get something under contract in time for you to move directly into the next property? So you have to anticipate all of these things if you're doing your job properly as an agent. Okay. Back to the financing thing, you've always got to take a look at the overall financial situation of clients, even if you're on the seller side. If you sell for the price that you're intending to sell for, because that's the best you're going to be able to do, is there going to be enough money from that to pay everything off that has to be paid off? Okay, it's not that unusual when we have sales closing and there isn't enough money from the proceeds of the sale to pay off the mortgages and encumbrances that are on the property. There might be a first mortgage, there might be a second mortgage, there might be a lien on the property, there might be a CRA lien that's there. There could be other debts involved. There might be executions or judgments against the seller, and there isn't enough money to go around. So if there isn't enough money to go around to clear up title on closing, we can't close unless the seller has an ability to come up with other funds from other sources to make up the difference, or there's enough time to go back to all these parties that intend to be paid out and try and negotiate something and make a deal. Say, yeah, I know you're owed this amount, but there's enough money to go around. Will you be prepared to take less than that? This is all we can give you. And maybe there's other security we can provide on some other property, or a promissory note, or some other arrangement is made. But you've got to make sure that you do your homework, make sure that we find out that there's enough money to go around. Even outstanding property taxes can come back and screw up a deal because there just wasn't enough money to pay off the mortgages, and there's a backlog of unpaid property taxes or utility bills, water bills on the property that have to be paid with interest and penalties, and there isn't enough money. So be diligent, understand your client, go through that whole process. Now, one thing that's really helpful, and we're going to talk about this in part 2 a lot more, is a bridge loan. If you're buying and selling, any client buying and selling, it's always a good idea to get them to apply and arrange for a bridge loan. Okay, that'll cover them. And I'll go in more detail of what that is in a few minutes. I mentioned before that the pre-inspection issues. When you do inspections and you find out that there are issues, then what? Can you negotiate this? Is it going to scare off the buyer? Does a seller really want to go back and fix all these things? If they do fix them, is the buyer going to be happy the way they're fixed? It creates a whole bunch of issues. So be careful to determine what can really be corrected before closing, what cannot be corrected before closing, and then how you're going to deal with that. And I'm generally a proponent of, for things that can't be physically fixed prior to closing to the satisfaction of both parties, which means sellers getting it fixed, buyers should have an opportunity to go in and look and check and make sure that it was fixed, and fixed by proper qualified people as well. But certain things may not, there just isn't enough time to get them fixed. So it's going to happen after closing. So now what are you going to do? What are you going to negotiate? Are you going to negotiate that the seller is going to come back after closing to fix it? Is that going to happen? Is the buyer ever going to be happy with them doing that? Or I'm sort of the proponent, you're better off negotiating maybe a reduction in price to cover the cost of fixing it, and let the buyer hire their own people after closing and fix it up to their own satisfaction. Okay. Sometimes the agents or the buyers would say, well, we'll just get a holdback. If you don't fix it, we'll just get a holdback. There's no such thing as a holdback. Okay. In the standard agreement of purchase and sale, a holdback is only available if the parties negotiate and agree to a holdback. Okay. And holdbacks are generally problematic for the reasons I outlined. If you're holding back so that the seller will come back in and fix it after closing, you're still going to have an issue. Did they fix it on time? How disruptive was it? Did they use proper people, licensed people to do it? And is the buyer going to be happy with it? And when does the holdback money get released, et cetera, et cetera? So there's a lot to negotiate with those things. So that's why I'm always of the view, sometimes instead of trying to negotiate a holdback, you're better off to try and negotiate an abatement of the purchase price, or a reduction of the price, or a credit to the buyer, and then the buyer will get it fixed to their satisfaction after closing. So just keep that in mind. You as an agent can play an important role with following up with the lawyers involved. Make sure everything is done. Is there anything I can do? Anything I can help you with? I get contacted by the good agents are contacting me all the time. What can I do? Is everything on track? Is there anything that has to be delivered? Does anything have to be translated for the benefit of my client? Should I attend with my client for the sign-up meeting to help translate it? If there's a language issue, there's lots of things you can do to help out. Make sure the seller has a proper plan to move out. Make sure they move out on time. Make sure they know they have to be out on the day of closing, and they should be out by 4 o'clock on the day of closing. Okay, there's case law that really allows them to continue moving out to 6 o'clock, but everybody should be encouraging everybody to be out by 4 o'clock at the latest. That's why there's a little bit of extra time just in case it's needed. Make sure they're getting out. The place has to be cleaned, has to be in proper condition, no garbage. They've got to do that. Okay, that's part of where you can play a role in that as well. Okay. Again, the last point on here is make sure you've taken a look at the mortgage loan liabilities, closing costs, make sure there's enough money for everybody to close. So you can play a part in that too, in tracking down some of those debts that might have to be paid off. All right, I want to get into part 2, and you'll see there's an overlap with a lot of this stuff and reasons why things don't close. Oh, I should mention one thing, because this is something just happened in our office this past week. I mentioned a bunch of different reasons why transactions don't close. So here's a story that you might find interesting. We're acting for a buyer. Standard residential transaction supposed to close last Friday. Everything's moving along fine. We do our title search, normal course. There was a refinance about 6 months ago, and there was a first mortgage and a second mortgage, and they refinanced the first and paid out the old first mortgage, and the second mortgage was a private mortgage, and it gets discharged from title. So, we're just proceeding towards closing. And the day before closing, we get notified by our title insurance company that they won't insure the property. They're denying insurance. And there's only really 4 title insurance companies in the province, and we deal with all of them. We have a great relationship with all of them because of the volumes that we do with them, and we try and spread things out. But some underwriter there said, no, we're not doing it. So we, obviously we're inquiring why. What's the issue? Well, the seller used a lawyer for that refinance 6 months ago, paid off these mortgages, and they're using a different lawyer right now to sell the property. And we need to know what happened with this private mortgage. We need confirmation that funds were paid from the refinance to pay out that private second mortgage. Like, they're looking for fraud. They're sniffing around for fraud. Why is they get suspicious? Just because they're using different lawyers is the first thing. So, okay, well, we need confirmation that we want to see the discharge that was signed and to see that monies were paid out. So it's not our transaction. We have to go to our seller's lawyer and say, hey, you got to go to the lawyer that acted on this refinance and find out and get confirmation. We need to see a copy of the discharge that was signed by the private lender, and we need confirmation that the monies were paid to pay out that mortgage. And it wasn't just someone fraudulently taking a mortgage off title, which is what the title insurance company was worried about. So we can't get a hold of the other lawyer. The other lawyer not responding. We're chasing. Finally, we get an answer from the lawyer that acted, and they send us a copy of, here's the discharge. So it was signed, some scribbled signatures, but not witnessed by anybody. And they say no monies were paid out and the mortgage was discharged. So that gets sent to the title insurance company and says, no, we're not going to insure this. We're denying coverage. So we're already looking, at the next title insurance company to see if they would take it. But the first thing that a title insurance company is going to say is, have you been denied title insurance coverage by any other title insurer? Because if so, they don't want to look at it either. So we knew that was going to be denied too. So anyways, we're telling the other lawyer, like, that's not good enough. We need confirmation what happened. And we get in touch with our title insurance saying, look, we got to get this insured. They say, no, we're not insuring it. So I call up the underwriter and I say, look, I don't want to hear that you're not going to insure this. I want to know from you what you would need in order for you to approve it. What information do you require in order for you to approve it? And it was basically, I need that lawyer that acted to confirm that they acted, for the borrower, that there was another lawyer acting for the private lender, and that if there was no payment that was made, then why was it discharged, and confirmation why was it discharged? And we went back and got in touch with her, and it turns out that they discharged for no payment on this property, but were given a mortgage on another property as security to replace the mortgage on this property. So all we needed to do is get written confirmation from the other lawyer that that's in fact what happened. And the judge says, if you get that written confirmation in proper form, then we're prepared to insure. So we're going back and forth because, again, we don't have the right as the buyer side to go directly to the seller's former lawyer to get this. We need the seller's lawyer to do it. Seller's lawyers not responding, not doing it, not moving quickly. We're now at the day of closing, by the way, trying to get this done in the after the day of closing. And we're chasing and chasing and chasing and not getting it. We finally get it right at the end of the day, beyond 5 o'clock. We get the written confirmation the title insurance company needs to satisfy them, because that's in fact what happened. So now we've got written confirmation from the lawyers. They paid out this private mortgage, but they got security in another property. It's legit. The lawyer knows the lender, the lawyer knows the buyer. There was lawyers involved. Everything looks good. They're prepared to insure, but we're out of time. We can't close. It's a long weekend, so we can't close until Tuesday. So we have to extend until Tuesday. A seller's lawyer says, oh, you didn't close today, you're in default. We're asking for an extension to the next day, and we'll close. We got money, we're all ready, documents signed, we'll close Tuesday morning. They send us a letter, no, you're in default, you didn't close. Okay, so that's what the clients had to sit with all weekend. On the Tuesday morning, I said, let's just send them the money, send them all the documents, tell them we're ready to close. They sent us a letter saying we're prepared to close today as long as you pay our seller $1,000 for the extension over the weekend and pay our additional legal fee for this extension of $500. So basically we want $1,500 from our client, and otherwise we're not closing. So I call up the other lawyer and I said, look, yeah, we couldn't close because we couldn't get title insurance, but we couldn't get the title insurance issue cleared up because of your inaction Thursday and Friday last week. We were chasing everybody. You weren't doing anything. We couldn't get a hold of you. We sent you a million emails. We sent you a million letters. We needed you to get after them. It was your delays. So fine, you want to close on that basis? We'll get instructions to close. We'll pay you the $1,500. We'll do it under protest, and tell our clients to sue you for the $1,000 and the $500 in legal fees because you caused the problem. So that's one choice. Otherwise, waive it. Let's just close. Your client will pay for your legals. Our client will pay for our legals. Everybody wants this deal closed. Let's get it closed. Wouldn't answer for a few hours. Wouldn't answer us. And then just said, okay, we've released, we're closing. And we closed. We didn't pay them the $1,500 and we just closed and got it done. So anyways, long story to tell you, just this is the type of stuff that happens. And no matter how long you're practicing law and how long you've been a real estate agent, there's always something new that comes up and some issue that comes up. And a lot of this wouldn't have been a big issue if I had a good lawyer on the other side of the transaction that would have just jumped on it the same way that our office did and tackled it right away and just got in touch with the lawyer and figured out the same way that I did. They say, no, you just telling us that, oh yeah, telling the title insurer, yeah, no funds were paid. That's not going to cut it. We need the explanation. But it was like pulling teeth. So again, it comes back to my advice to you always as agents, you want the right team. I always love when I have a good, competent lawyer on the other side of a transaction. It makes my life way easier. Okay, we could have got that deal closed on time on Friday if I had a better lawyer on the other side that was proactive and would have jumped on it a little faster than they did. It also really helped. We talk about teamwork. The fact that my firm has such a good relationship with the title insurance company because of our history together, that they know that when I call them up, I'm not bullshitting them. I'm giving them the straight goods. I'm trying to get the deal done. And when I say to them, tell me what you need, and if we can get that, I'll get it for you. If it's not available, fine, the deal won't close, right? I'm not going to try and force them to insure something and take a fraudulent risk, okay? But they reacted, they responded quickly, and they went back and said, okay, this is what we need. Get us A, B, and C, and we can get this approved. So we went back, got A, B, and C, we got it approved and got the deal done. So that's part of like my team. I need a good relationship with title insurance people on the other side that'll respond to me. So anyways, let's move on. Buying, selling the same day. What happens? People are always buying and selling in the same day. Like, is it a bad thing? Is it a good thing? We close transactions all the time for people closing the same day. It's a great thing for anybody. If you can coordinate that and you can get it done the same day and don't have to put anything in storage, you don't have all kinds of expenses get eliminated. Greatest thing. Close your sale, use the proceeds from the sale to buy your purchase same day. It's a win-win, greatest thing. We do it all the time. Problem is, there are issues because issues come up and you just never know when one of these transactions is going to go off the rail. And do you have enough time? Can you get them closed? And what happens if you don't close? Because if your sale runs into a problem, you can't close on your sale for any of these reasons that we've talked about. Okay, foreseen or unforeseen. If the sale doesn't close, there isn't money to complete the purchase. So that's a problem. Okay, so yes, we do it all the time, but our more full answer is yes, but there are issues. There are risks with same-day closings. Okay, there's unpredictability for all these reasons that we've talked about already today, why transactions may not close or may not close in a timely fashion. Okay, so we have to anticipate it as agents. We have to anticipate that as lawyers for acting for our mutual clients. Okay, there's certain problems that come up. There's underwriting conditions. There's problems getting financing. Some, they're prepared to close, supposed to close today, but maybe there's an underwriting condition that hasn't been satisfied yet. And now the lender runs out of time to get the money advanced in time. There's all kinds of issues that could come up. So we have to anticipate these, try and eliminate them, and always have a plan B. Okay. So we want to know what could prevent or delay closings. What do we do to keep it going, especially when it's the same day? So obviously, to complete a purchase, we need the proceeds from the sale to close. So there's two general scenarios that come up with this. Scenario one that we'll talk about is the buyer can't get their financing, okay, in time. It's supposed to close today, but they can't get it. Either they can't get it till tomorrow for some reason, or it might be delayed. Maybe they didn't satisfy certain conditions. They can't get it at all. They got to go to another lender. Maybe they need a week or two. But in either event, it's a situation the buyer needs an extension. They don't want to get out of the deal, but they need an extension because they can't close on the day they're supposed to close. The other scenario is the buyer's not going to be able to close. They're not going to be able to get their financing or whatever. They're going to be defaulting, and they're just not going to have an ability to close. So those two different scenarios and how are we going to deal with them. So in the first scenario, where we want to close, but we just can't close, we need more time, the buyer has to request for an extension. And that might mean if there's more than one transaction, if there's a sale is going as well, then we need an extension. We might need an extension there too. You never know how far down the chain you have to go. So we may need to be negotiating more than one extension in that scenario. And whenever you're requesting an extension, you don't have a contractual right to an extension. It's only something that you're requesting, and it has to be negotiated, and the terms of that extension have to be agreed to. The extension can be denied. And if the extension is denied, the buyer's in default. Buyer's in default, the buyer loses their deposit. Seller has the right to sell the property to somebody else and can still sue that defaulting buyer for any other damages. And the damages might be because of timing issues, because the next sale may not take place for a few months, so they have to carry the property. It might be a difference in purchase price. It can be all of those things, additional legal costs, etc. So we never want a buyer to be in default. Okay, so we've got to try really hard to negotiate an extension. Some of that is negotiated by you as agents or with your involvement, and some of it is through the lawyers. When you get into this situation, you usually want the lawyer involved. And oftentimes I'll say, no, we don't want an amendment done between the agents. It's better for the lawyers to put this in an exchange of correspondence between them to negotiate these terms of extension. But a lot of times we need input from the agent in the process as well, because we're on the same team. Okay. So we say, we need an extension. What are your terms for extending? Now, if it's only a 1-day extension or something, it's usually pretty minimal. The longer the extension request, the bigger the shopping list of terms that they might be imposing on you. But a seller basically wants to be kept whole. So if they're going to get their money on Thursday and now they're not getting their money until Friday, they're entitled to interest on the money that they would have had for 1 day. Rates are low right now. That doesn't amount to a lot. They would have been paying out their mortgages today. Now they're going to pay it out a day later. So cover them for those type of costs. They got to keep the place insured for another day. Those are minimal costs. Okay, they're not deal breakers. The longer the extension, the tougher it is to negotiate for those type of costs. If you're on the seller side, I always want to know, does the buyer really have an ability to close tomorrow? If you're asking for 1 day, show me your commitment. Show me that they're prepared to close tomorrow. Or if you're asking for a week, show me that you've got a commitment and a lender that says, yeah, I can get this closed in a week. I want to know that it's real before I agree to anything. So there's a lot of issues that come up with that. When you're in scenario 2, when you really have a buyer that's not going to be able to close, now what? So if the buyer defaults on the sale transaction, your client is going to default on the purchase transaction. Like, there's a chain effect. Okay, so they've got to come up with another source of funds. Okay, so if the buyer that was supposed to complete your client's sale isn't closing and you needed those sale proceeds in order to buy, you're not going to have that money. So how are you going to close? You got to come up with that money, or you are going to be default. Your client's going to be default on their purchase as well. So that creates a big issue. So, which leads me back to this concept that I promised I would get back to, is time is of the essence. In every standard agreement of purchase and sale, it says time is of the essence. So that means whenever there's a date and a time, 5 p.m., 11:59 p.m., whatever that time is, that has to be strictly adhered to, unless the parties agree to change that in writing. Okay, so you have to make sure that you're always following that. There is no right to extend. Time is of the essence. You're supposed to search title by February 24th. If you don't, and you search title and send your requisition letter after that, then anything that you're asking to be fixed up on title, the seller doesn't have to do, because you have to make that request by February 24th. Time is of the essence. Okay. If same thing with irrevocable time, it has to be signed by 11:59 p.m. today. Then if it's signed at 12:01 tomorrow, they're in default. They didn't comply. There's no deal. Time is of the essence. If the closing date is supposed to be February 24th, it's not a suggestion. It has to close today. Time is of the essence, unless the parties in writing agree otherwise to change that date. Okay, so there's no unilateral right. Now, most of the time, parties get in trouble if things go off the rail, and we're getting to this. Usually, your parties have to act reasonably, act good faith, and try and negotiate proper terms of an extension. You can't be unreasonable, et cetera, et cetera. But we always have to look for practical solutions too. And we got people in moving trucks that really want to close, and then it puts a lot of stress on everybody. So not only do we close on a date, but we're always trying to close as early in the day as possible. Like, we always want to close a sale as early as possible in the day, so we have the money to transfer to complete our purchase. So sometimes we successfully close a sale, but it may have dragged on till right near the end of the day, and there isn't enough time to get that money transferred over to complete a purchase. And just the purchase has to be extended. But we have to adhere to that time of the essence situation. Okay, so if it has to close by 4:50, it has to close by 4:59. So we got to make sure that the funds are all delivered. Okay, we got to get those purchasers' funds. If we run out of time, we've now closed the sale, but it happened really late in the day, it's almost 5 o'clock, there isn't enough time to get the money to complete our purchase. So we'd have to go to our seller and say, hey, we need an extension. We're ready. Here's the documents. We've got funds. We can show you confirmation. We got funds in our trust account. We're just out of time to send it to you today. We need an extension till tomorrow. But it's still something that has to be negotiated, because the seller can still take the position, no, you had to close today. You missed the time. You didn't get the money to us. You're in default. Too bad. So sad. we're going to sell to somebody else. We're keeping your client's deposit, and we are going to move on, sell to somebody else and sue you for damages. So what are your other options? Don't close the same day. Try not to close the same day. Try and leave a gap between the closings to give you a chance to close the sale one day, make sure you got the money, and then close the purchase. But if you're doing that, there has to be a plan too, because if you're closing their sale first, they have to have a place to live until they close the purchase. Things have to go into storage. There's costs involved for doing that too. There's certain inconveniences. Okay. You can try and do it the other way too. But if you're selling first and they have to do that, that's great, because you have arrangements have to be made. They need some sort of place to live, short-term rental. They can live with their family, with their friends. You can offer to invite them into your home. I've always tell people, sorry, I'm full, but everything's got to be put in storage. You can't move stuff into the new house because you've got this gap in time. So that's one option. Okay. Now, if you're doing it the other way, buy first and then sell. Well, how do you buy when you haven't sold? You don't have the money from your sale. Aha, back to the bridge loan that we talked about earlier. That's the purpose of arranging for a bridge loan, which banks and lenders are very happy to provide. Okay, and what's a bridge loan? It's a short-term loan for a few days. It might be a week, 2 weeks, but it's bridging that gap, allowing you that they're going to lend you money to complete your purchase on the basis that you agree as the buyer of that property that when your sale gets completed a few days later, that bridge loan will be paid out of the sale proceeds. Okay, so what happens in practical terms is the lender agrees to provide this bridge loan, and usually the lender wants confirmation from the lawyer acting on the purchase that they're also acting on the sale, and they want an undertaking from the lawyer that they will repay the bridge loan from the sale proceeds. And as long as they get that, the lender's usually prepared to give that. So this allows for a short period of time, this client's going to own two properties. They're going to own the property they're buying, and they still own the property they're selling for a few days or a week or until that closing date comes back. So they've got this additional loan that they got to pay up, but it's for a very short time period. So now you've got a few days. The client can take their time moving in. They've got this gap. They can renovate. They can do things like that. It alleviates a lot of stress. Okay. So what exactly is a bridge loan? It's just this short-term loan. Now, the rates are so low right now that it's hardly costing any money. Banks usually charge an administration fee. It might be a couple $100 to get it processed, and they're going to charge you interest on the amount they give you for this few days. Okay, but the rates are so low that it's great insurance to get these transactions closed properly. It's not expensive, especially in the big scheme of all the other places they're spending money in this whole process of moving. This will be like the least expensive thing that they're doing. And it gives them a great protection for this. Okay, so, and the banks will do it, the lenders will do it because they're using the equity on the sold home, and they're also using the equity on the new home because they can be covered both ways. Now, usually when it's just for a short period of time, there's no security that's given to the lender for the bridge loan other than a promissory note. It's just the buyer signing a piece of paper saying, I promise, I acknowledge I'm borrowing this money for this week until my property sells, and I'm paying, this is the interest rate that I agree to pay. And I promise that this will be paid out from the sale transaction. I've instructed my lawyer to pay it out from the sale proceeds. That's usually the only document that's required by the lender, other than they want confirmation from the lawyer that yes, they are acting and they will comply with that. Okay, they want that undertaking the solicitor, they're going to pay the bridge loan. That's it. Okay, when it's a short-term bridge loan, that's all they need. It's really inexpensive. It's not a lot of documents. It's a pretty easy process to go through. Okay, now they have to go through an application process with the lender. There's things that are going to have to head to the bank and make sure they do that, but it's not that complicated process, and I certainly encourage it. Now, if there's a larger gap of time between the closing dates, the lender sometimes says, okay, we need more than a promissory note because there's 3 weeks between these closings, and we haven't been able to satisfy, we're not sure that the sale is going to happen on time. What if the sale doesn't? What if it gets extended further? We don't want these loans to be outstanding for a long period of time. Maybe they don't trust the equity completely in the properties, or the ability of them to just be able to sue the client on the promissory notes. They might say, no, we need some security. So sometimes they instruct the lawyer, prepare a mortgage. We're going to register the mortgage, or first prepare a mortgage. We want their mortgage be in the file, something that they will put a mortgage on the property that they're buying as an additional mortgage, or the property they're buying. So it'll be a second mortgage on that one. And it can be a mortgage that'll be registered on the property that's being sold as well as security. Sometimes they instruct us just get it signed and available in the file. So if the sale doesn't close when it's supposed to close, we'll instruct you to register it at that point in time. Sometimes they say, no, just go ahead and register it on both properties. And then when the bridge loan gets repaid, we'll discharge it. So even in that scenario, I still encourage you to do it, or encourage your clients to do it, because yeah, there's additional costs, there's some additional legal fees and registration costs of things for getting the security done, but at least it allows you to have the bridge loan. So it's still a pretty good option. So with the rates as low as they are, it's really inexpensive way to ensure that your client can be covered. And I would tell everybody, every agent that I talk to, I encourage you to tell all your clients, okay, when they're buying and they're selling, even if it's a same day closing, okay, unless they've got really deep pockets and they've got all kinds of resources, it's a great idea to arrange for a bridge loan, hoping that you never need it. If you don't use it, you don't pay the administration fee. You're not paying interest on it. You can have it available to you. Everything's signed, ready to go, but you may not need it. If everything closes on the same day, your purchase sale, your clients closes the same day, everything goes smoothly, you never need the bridge loan. But you have it in place just in case, okay? Just in case something goes off on one of these transactions and your sale can't go ahead because the buyer's running into some underwriting issues and you have to close on the same day. So you're not going to have the proceeds from your sale, but you advised your client to be smart. They arrange for a bridge loan and they can draw on that bridge loan to be able to close their purchase, even though their sale didn't close. Okay. And then eventually that sale will close to that buyer or some other buyer, and the bridge loan will get paid out. So bridge loans are a tremendous strategy, should always be considered. And you as an agent would not be doing your job properly if you didn't have some discussion with your clients about considering it and arranging for it, even though they may never use it. Hopefully they won't use it. But as you can see from this discussion today, you never know what's going to happen. You never know where the transaction might go off the rails a little bit. And yes, we're very successful at negotiating extensions. Sometimes the terms are really fair. Sometimes they're very one-sided. Sometimes they're not fair. But there are scenarios where we can't get an extension negotiated properly, and one party is in default, and that's not a good situation for anybody. So go the extra mile, be diligent, understand this concept, make sure you get the lawyers involved in the process as well, and make sure things are done properly. So I want to leave that there and thank you all for attending. And I'm going to stick around for questions, as I'm sure there might be. And if anybody doesn't have questions they want to do here, get in touch with me. I always get some people contacting me after we do one of these webinars with some different follow-up questions, different scenarios. You can't answer everything here, but you can always do it privately. So, but thank you everybody for attending.
Guys, if you have a question, you just feel free to unmute, or you could put it in chat, or you could just use the little raise hand icon. Oh, actually, sorry, you can't use raise hand. So chat or mute.
Okay, good afternoon, David. I have a question, a little off this topic. Yeah, but is it possible to get untitled someone who is not living in the country, or someone who is below age 18 on the title?
No to someone below age 18. You have to be age of majority to be on title in Ontario. But there's people that don't live here that own properties in Canada all the time. Like there's no restriction on anybody owning properties in Canada if you're not a resident of Canada or a Canadian citizen. Now, there's certain ramifications for that, certain costs that might be incurred at the time of buying. There's certain taxes and issues that have to be dealt with at the time of selling properties. But the general answer is no. Like, there's a lot of properties owned or partially owned by people that aren't residents of Canada or they aren't citizens of Canada. So that's the short answer. And by the way, thank you for bringing this question up, even though it's not part of today's topic, but that's specifically what is the subject matter of next Thursday's webinar, where the topic is non-residents of Canada and what are the issues that come up both on the buying side and the selling side when you're dealing with somebody that's not a resident of Canada or a citizen of Canada. So that's next week's topic. So please tune in next Thursday, same time, same channel.
Like we planted that question or something.
Yeah, really, that's good.
Yeah. Okay. Thank you.
Anyone else? Once again, quiet group. I'm sure they're going to fill up your voicemail as soon as we're done here, though.
Yeah.
Okay, well, if that's it, guys, then I'm going to end this for today. Thank you so much for attending, and we will see you next Thursday, same bat time, same bat channel. Have a good day, everybody.
Thanks, everybody. Stay safe.
Bye-bye.